Thank you all so much for being here. We're so excited to be sharing this presentation. It's a reprise from our annual convention. It was described in our evaluations in numerous ways, but including excellent and insightful panel, another must-see TV program for NELA members, and best panel of the convention. So for those of you who don't know, I'm Ashley Westby. I'm NELA's program director out of our Washington, D.C. office. We're thrilled to have all of you, especially those of you who are going to travel boot camp next week. I'm going to take just a second to introduce our presenters who are so incredible. We're thrilled to have them back with us. So your presenters today are Brian Foley, who practices employment and defamation law solo in Philadelphia. He's helped pioneer teaching storytelling in law schools and CLEs and co-created the Applied Legal Storytelling Conference Series. He's a lecturer at Rutgers Law School, where he teaches employment law and evidence. And before practicing employment law, he was a newspaper reporter, a federal judicial law clerk, worked in big law, and entered academia. Miriam Hussein is senior counsel for Berger Montague's Chicago office. In the employment law group, Ms. Hussein primarily focuses on wage and hour, class and collective actions rising under state and federal law. And prior to joining the firm, she developed interdisciplinary impact litigation cases and legal strategies to advance economic and social justice. She also represented migrant farm workers in Illinois, filing cases alleging racketeering, human trafficking, forced labor, and FLSA violations. And finally, Laura Mariachi is the co-managing partner of Counsel Mariachi. She's been practicing plaintiff's employment law for 21 years and is the lead trial lawyer for many of the firm's most significant cases. Most recently, she was lead trial lawyer in Phillips v. Starbucks Corporation, in which the jury unanimously awarded $25.6 million to her client in a high-profile race discrimination case. She's tried many discrimination and retaliation cases to verdict in state and federal court. So as you can see, very impressive panelists. Any of your questions can go in the Q&A box or in the chat box. We'll be monitoring both. If you have any questions about technical matters or CLE, you can ask them there as well. All right, go ahead.
Hi, everyone. It's nice to see you all here. Brian, I'm going to start with you.
Okay.
You know, storytelling, it's a popular topic amongst litigators, amongst lawyers. I think it's really important to be thinking about the story from the beginning. I myself think about a story or a theme when I start drafting a complaint or a demand. But why do you think a story is important to tell?
All right. So let me just get that screen shared. All right. So the story is really the way that people think about things. Story is what we're all trying to do. You know, when you think about a jury, and if you've ever been on a jury or talked to jurors, they're often trying to figure out what's the story here, right? You step into any kind of event in the middle of something going on, and you're trying to figure out what's the story. And that means a lot of different things. It means who are the characters, who are these people, what are they trying to do? And I say that because that's how we think. And even if we as lawyers wanted simply to make the law, the legal problem, the trial into a logical syllogism, the jury would still be trying to think about what the story is. So I have a couple of PowerPoints that just, make the point. Story is the most powerful tool of persuasion. There are countless times when you think about arguing with people in your own life, maybe like before 8 years ago, arguing with people, but you could actually, you might throw facts and data, etc., at people, but that might not convince people, but telling them a story often will. So the idea is that it's the most powerful tool of persuasion that we have. Our job, kind of doing a sort of syllogism here, a lawyer's job is to persuade a decision maker. Therefore, a lawyer should tell a story, right? So use stories to make your points. Why else is it important? Because, again, we're trying to get people to see things our way. All right. So I want to go through a couple of building blocks first off, so that everyone knows what we're talking about when we talk about story. And I want to start by saying that one of the ways I got into teaching storytelling was because I was teaching legal writing, And the legal writing textbooks, almost all of them would say, your facts section, and it would say, tell a story. But it didn't tell you how to tell a story. It assumed everybody knew how to tell a story. And I was thinking, I had a shelf of books on, on my wall at that point about how to tell a story, how to write a novel, how to write a movie, etc. And I'm thinking, well, if people need to be taught how to tell a story who want to become professional storytellers, then maybe lawyers need to be taught how to tell a story. Now, there are some people out there who are natural storytellers, and you've probably encountered such people, and they're amazing, and they make great trial lawyers, and I think that's a big part of why. But anyway, I want to talk about a couple of definitions. What do we mean by story? A story is a character-based and descriptive telling of a character's efforts over a period of time and in a time and place, which is the setting, to overcome obstacles and achieve a goal. So there's got to be a conflict. The character has to have a goal, etc. Setting matters. We all know this from employment law, just basically, where did this happen? If something happens at the office versus happens at somebody's home, it makes a difference. Or after hours from work, it can make a difference. Even if legally it doesn't make a difference, it makes a difference in jurors' perceptions. So something that happens even in a different jurisdiction is going to matter. And importantly, the same person will act or react differently in different settings. And then character, very important. We talk about when we are thinking about our legal stories, we have to think about who are these characters? Who is my client? What does my client want? And pointing out a few things about character. Up here, I've got character matters. Different people act differently in the same situation, and we're all who we are as a result of various situations we've been in. Here, I like to show this, which is, I'm in Philadelphia right now, so think about Rocky. Think about the character of Rocky, and how he might react in particular situations. Now compare that to Hamlet, right? You couldn't really have Shakespeare's Hamlet with Rocky. I mean, first off, you'd have to call it Rocky, but it just wouldn't be the same, would it? I mean, you try to picture it and picture Hamlet as Rocky. You just can't picture to punch this guy or not to punch this guy. I mean, it just wouldn't work. So we need to think about who the different characters are. So when we talk about legal storytelling, we're talking about something really different from, writing a novel or a movie, because we can't invent these people. We can try, we can try to make the person, our client, into someone she isn't, but anyone who's done any of this sort of work, law work, knows that that person will come apart on the stand and the real person will come out, certainly under cross-examination. So we have to think about, what happened in our case, and think like documentary writers, take these facts that actually happened and organize them as a story. And part of doing that is, again, thinking about who are the characters, who's the good person, who are the villains, and also what is my character's goal, what's my character trying to accomplish, et cetera, et cetera. And last little bit for this introduction is if you want to delve deeply and you're thinking about your case, I think it's a good idea to use almost a template of saying, who's the good person, who's the villain. Again, pretty sure your client has to be the good person, right? That's just the way it works. But you have to think about who the villains are. And as I like to say sometimes, if you can't think of who the villain is, maybe it is your client, right? But in any event, you need to identify those people, because if you don't, the jury will. All right. And any other decision maker, any other fact finder will try to figure out who are the heroes, who are the villains. And character types, there are going to be different characters in your case. And one thing to do is to think about, who are these people? What are their roles? Because if they have certain roles, they act in expected ways, versus if they have another role. Okay. This is two bears fighting. We think about the conflict in the story. Which bear is in the right here? Can anybody tell me who's correct here? Which bear are you rooting for? And the answer is pretty much no. Maybe there's somebody out there who knows one of these bears, but for the most part, these, we don't know, right? I don't know what's going on. I need to know why they're fighting. How did they get here? What are they fighting over? Maybe they're actually playing, right? For all we know, but I don't know who's the good bear and who's the bad bear. And think about a case, your jury won't know who's the good and bad bear, unless you give them the information to show them. And showing sometimes is better than telling. The jury, even if you were unclear on who is the good or bad bear, the jury's going to be trying to figure out, right? Whom am I going to root for here? Here's another one. I showed this last summer as well. Who's, which person are you rooting for? Well, what's going on here? First off, we have a snake, and it might be a baby monkey. I'm not sure. I'm not an expert. I'm not a zoologist. And this is a monkey. Most people, when we've done polls, root for the mammal. It's a fellow mammal. And you can look at this and say, what I think has happened here is this snake may be trying to kill this little monkey or some other mammal, and the monkey's trying to save this. If that's the case, if this monkey is trying to save another creature, we're rooting for the monkey. And again, we identify with the monkey as a fellow mammal. You could maybe twist this and say, here's a monkey trying to steal the hard-earned food that this snake is trying to eat. Now the monkey is the villain. Maybe this little animal is just being paid to be there. I don't know. But in any event, we can tell more from this picture than we could from the previous one about what's going on and which side we might root for. But most people, most of the time, would see this, automatically root for the monkey, automatically think the monkey's trying to save a fellow mammal, if not fellow monkey, and be rooting for the monkey, right? So it's very easy if, this is an analogy, of course, but if your client is the monkey and the employer is the snake, right? We know which side we want to win. We don't have to do a lot of work even to find that out. There are some employment lawyers who would twist this and say that the monkey was a child care worker and did a bad job, got put on a PIP, failed the PIP, and then the employer took the child away, and now this isn't just a monkey, it's a disgruntled former employee. But it would take a lot of explaining to get there, right? You'd have to reverse all of your instincts when you see this to end up believing that was the story. Okay, so hopefully in your case, the story is one that's somewhat automatic as far as as far as what's going on, and then you can slot your client into the appropriate slot. And last but not least, the conflict types. This is classic. You can probably fit any any conflict you know of in any novel or movie, a decent one at least into this, person versus machine, person versus society, person versus self, person versus nature. We've seen a lot of that this week. Nature versus everyone, same thing. Person versus person. Now, my point is this. If you see a conflict where a person is fighting a machine, and it might be like a big employer, right? It can be a metaphor. You generally pick the person. Person versus society. If it's a criminal, you're going to pick society, but if it's a wrong-headed society, you will pick the person. Person versus nature, we usually pick the person, especially if it's like in a storm or something like that. But person versus person, we don't know which person to pick. So when you're framing your conflict, you might want to think about, and what I call an automatic win conflict, getting your client into the conflict and being the winning part of the conflict automatically. We all have stock stories from our experience and from watching movies and reading novels. And then again, different characters, if your client is a creator, that client is going to bump into particular conflicts that creators bump into. Caregiver, same thing. Warrior, same thing, etc. So those are really important things to think about when you're thinking about your story. What is a story? Who are the characters in the story, and how can I frame the conflict such that my client is the automatic winner of it. And when I say automatic, of course, that's there are many qualifications to that, but it's getting you ahead of the curve as far as what story the jury is going to finally see here. I'll stop there.
One thing that you said, you've like talked about these different characters and the way to frame the story. I like to think of it, all of this as encompassing or as being encompassed in a theme, right? And when I start to think about my cases from the beginning, I think about what's the theme. And sometimes the theme is as simple as thinking about what's the elevator pitch to somebody that's not a lawyer, right? What's the one fact that they just can't really let go of? So in a wage and hour case, if somebody asks me what a case is about, I'm not going to say, oh, it's about the fluctuating work week and they weren't properly paid overtime, and go into the details of it. What I'll say is this employer is committing wage theft and they're not paying their employees, right? And you could sort of frame it that way so that the individual that you're talking to really relates to the employee. I think sometimes what gets difficult is, Laura, you're always talking to juries. I'm always talking to judges. Those are two very different audiences. And so, a judge might be more sympathetic to a business, whereas a jury may be full of working people and they see themselves in the employees. When do you both think you should start thinking about the theme or the story, and how do you do that? Laura, you want to go first, or Brian?
Yeah.
Sure.
I'll quickly say right away, but Laura has a lot better info on that. But very quickly, the theme can be boiled down sometimes to there used to be a book called something like Everything I Ever Learned. Everything I Know I Learned in Kindergarten or something. And you can think of the themes like a breach of contract. That's a broken promise, right? Like it's not a breach of contract, it's a broken promise. Or we talked about a couple minutes ago, person versus machine. People should win. Person versus society. Society shouldn't gang up on people, et cetera, et cetera. So breaking it into these sort of little truths that we learned in kindergarten. But I'll defer now to Laura. Thanks.
Yeah, thanks, Brian, and thanks, Miriam. It's for most part the cases. Well, I do all employment discrimination from the plaintiff side, like most of people on this call. But I don't do wage and hour, and so it is a little bit different. And virtually all of our cases are in front of a jury. The theme often comes down to an abuse of power. That seems to be the common thread throughout. I don't feel often, though, when I'm walking in that I automatically have the jury's sympathy because I represent an individual person. I think there is actually some bias against the individual because people think that society's too litigious and what's wrong with this person? They're not missing a limb. Why don't they just move on and get another job? So I feel like coming into jury selection, that's often the hurdle or the place where I find. And in terms of the story, right, from a trial standpoint, once you get past the initial stuff with the judge, your first opportunity to talk to the jury in jury selection is really to come out with that elevator speech to the extent the judge allows it about your case. You know, I think it's important to just be careful about the language that we choose when we're talking to the jury, as opposed to coming at it by saying, you know, my client is the plaintiff and she alleges X, Y, and Z. No, the plaintiff doesn't allege. This is what happened to your client. And so that foundation for it starts in jury selection so that that is the initial view that they hear about the case. And then you have to build upon that when you get to the opening. And I feel in the opening that the jury, once you have your jury, that's the best part because now you can settle in. And you know, this is your 8 people or so that you're going to be with for the next week or two. And they're nervous. They want to do the right thing. They don't know what they're there to do exactly. And so our role is to calm them down a little bit right away. And the way that we do that is by very clearly telling the story in a simple way without, you don't need, sometimes people think, well, I'm a lawyer, so I'm going to impress them with big fancy words. That's not going to be helpful to the jury. You don't need that. They're trying to figure out who to trust and whose story makes sense. So personally, I can just speak from the way that I approach it is in order to have the story make sense, you need to understand as many of the facts in the minutia and detail of that case as you possibly can. It's almost like, you know, if you had to solve a murder mystery, okay, what happened at every part of this day or whenever this event occurred? I want to know every minute of every day. I want to piece together the text messages and the video and the emails and everything. Same way in employment law, I'm trying to get everything I possibly can, look at this in excruciating chronological order so that now, not every email is going to be important. A lot of those emails are going to be completely irrelevant to it, but that's the lawyer's job, is to figure out what's important. But when to figure out what's important is, does it make sense in the story of what occurred? And I think you know, when you were talking, Brian, about the who, what, where, why, when. Sometimes I'll even start off my opening with those things on the screen. Who are we talking about here? Okay, this is my client, Ashley Westby. You know, she works for Neil, or however, you know, you just talk about that person and who is the defendant. Not that we're suing Neil. And then, you know, what is the what happened? This person was terminated. It's those are things that people recognize from high school learning about journalism. So that it's not, those are not foreign concepts to a lot of people. And now they're settling in because now you're talking in a language everybody understands. And, you know, I don't, if anybody, I'll tell you the other thing that's a little difficult about this, when we were doing this live, we had a live audience in front of us and it was very interactive. And we could see the person that we were talking to and the reaction that we were getting from the crowd, good or bad or facial expressions. And it's the same thing when you're telling the story in front of the jury. You want to be very tuned in to their reaction to things that you're saying. Could be a very small, usually they're very good about being stoic, but it might just be an eyebrow going up or just the way they turn their shoulder or all of those body language things you're trying to read and then sort of adjust your story to maybe what I just said didn't make a whole lot of sense. Let me try it again and say it a little bit differently. And here we have 89 people on this Zoom and we can't see anybody and we can't see anybody's reaction. And so that makes it much more difficult, but it definitely highlights the fact that it's easier and it's better as part of your storytelling process to be able to react to the reactions of the jury.
How do you, Laura, make your side sound more credible than the other side? Do you have any tips?
I from the very beginning, um, you want to answer, you don't want to speak in conclusory statements. My client was terminated because she had a disability and and I'm going to prove to you that that was illegal and that they shouldn't have terminated her because of her disability. Like th that's conclusory. Why? What, like we talk about in our office a lot, like in analyzing a case, the why. So the why the person was discriminated against may have been the disability. But what's the why? Why? Is it because they hate disabled people? I mean, if you stand in front of a jury right away, they're like, well, what are you saying? They hate disabled people, they hate pregnant people, they hate, you know, that doesn't ring true for a lot of people. But if the why behind that, for example, in a disability FMLA case or a pregnancy leave case, that person has to go take leave because of the disability, and that's going to cause disruption in the workplace. And disruption in the workplace is going to cause some annoyance and irritation for those that are left over. The shift has to be covered, or some work is going to go away, or maybe the sales numbers won't be as good that month for the supervisor. These are things that the employer has to deal with under the law because they have to provide the accommodation that is being requested for. So the why now you're tapping into um, a a reasoning that people now it makes sense to them. And now your story and how it rolls out is more credible than them saying, well, it's just so happened when she came back from pregnancy leave, she was the worst employee we ever had and we had to get rid of her. So you're competing against whose story makes more sense and is supported by the evidence that you bring out either in testimony or in the documents.
Thank you. I think it's really interesting to talk about the difference between standing in front of a jury and also brief writing, which is so much of what I do. I do complaints, I do discovery, I do the brief writing. And I think even in a deposition where you're deposing somebody who's obviously adverse to you, you're taking their deposition, even framing that in the story, it can be really effective. Do either of you have thoughts on how to do that effectively? I mean, I have thoughts, but I'd like to hear what you have to say.
Well, I
Laura?
think, yeah, in terms of are you talking about like when you're addressing the other side or what the other side's position is on the
Yeah, but
defense?
well, both, I would say.
Um, Yeah, I mean, practically speaking, when I'm trying the case, I don't spend a whole lot of time even looking over at defense counsel table. I don't spend as much as I possibly can. I don't spend a lot of time getting into fights or even pre-trial. I try to keep it very surface, very, very friendly. Um, I think virtually all the people I've tried cases against, I could go out and have, lunch with. It's just detaching yourself emotionally from what is happening as best as you can in terms of vis-a-vis what the conduct of the defense is. The worse they are and the more obnoxious they are, the happier I am. I'm like, please go for it. In terms of addressing them to the jury, to me, they are Walmart's counsel. They are McDonald's counsel. They are McDonald's. They are Amazon. So, that's just how um, approach it from dealing with the other side. They're almost irrelevant to me because I'm telling the story and my story is really good and I really believe in my story. I mean, I think that's the other thing as plaintiffs, employment lawyers, that we have this amazing benefit or advantage over the defense because we don't believe in the case, we don't have to take it. If it falls apart, you can settle it. The guy on the other side of, Morgan Lewis, wherever, he has to try this case no matter what. and
Mhm.
whether he believes in it or not. And so I think that belief in your client and belief in the wrong that we bring into the courtroom is they can sense that. So I think that's like a really cool advantage that we have that we should tap into, be it recognizing that.
That's a great point. And someone, I think it was Joyce Collier told me like our advantage as the plaintiff's lawyer in these cases is like our passion. And that actually can really fuel you. Like when you think, and I'm sure everyone's had this experience that, getting up in the morning, if it's a case you believe in, it's a different experience from if you have worked in big law and are working on a case you really didn't care about, no matter how much you try. So I think that's important. I want to address one thing about the storytelling and dealing with it in depositions. One thing and I know there are different views on how much you want to show or how much you want to get into stuff in depositions. But I think depositions are a great place where you can test out, especially the other side's story. When they've given explanations for things, you can spend time with that witness and keep asking, well, why? How come? Or, well, that how does that make sense? I think depositions are particularly good for going for and taking apart the you know the internal logic of the story of the other side and showing that this just doesn't make sense, right? And challenging them on that, because of course, if it doesn't make sense from a business sense, if it doesn't make sense from a how most people act most of the time sense, then it starts to look like whatever it is you're trying to prove, discrimination, retaliation, what have you. I'd say especially retaliation. It's like why did you deprive the plaintiff of this particular task when this task would have helped your company, et cetera, et cetera. Um, so I think depositions are particularly good in that sense, and the internal logic of a story, and whether it makes sense or not, whether it comports with our experience. I think that also goes a long way to credibility as well. It just makes sense. You don't have to stand up and feel embarrassed about telling a nonsensical story, which I think people on the other side are often doing that. And I sometimes wonder how they're able to do it, but that's why we're here and they're there, I guess.
Yeah, one thing that I do during depositions is, when I write my outline, I have what the law is and what I need to prove the law and the documents that I need to prove whatever the factual things are. But I also have the different themes of the case. And like you do, Brian, I sort of tease out all of those themes using the documents, talking to people, and I do a lot of class action work. So it's not just about the individual, but isn't this a theme that encompasses all of these people that I'm working for, this entire class, this entire collective? And didn't it happen in this case, and in this case, and in this case, and in this case, and sort of tease out all of those parts of the story? And if you can tie it up there at the end, it's great to use that sort of deposition testimony later on.
Yep.
Laura, you said something previously about showing and telling the story, or maybe it was Brian, I can't remember now, but how do you tell a story? How do you show a story versus telling a story? Do you use props? Is it the way that you tell the story? Like what sort of things do you use?
Yeah, I mean, I personally think it's really important to be as visual as you can with the jury. In opening, I will often use just an old-fashioned PowerPoint, and sometimes it's just pictures. It's, if the defendant is AT&T, it might just be a picture of an AT&T off the internet, like a shop. It just gives them that visual of, okay, that's who we're talking about. In terms of organizational, an org chart, so to speak, when you're dealing with employment law cases, I always have not just an org chart, but one with pictures on it. And it will show that so the people can see the pictures of the folks that they're going to meet during the course of the trial and go through that with them. And then I always blow it up on a big old board in color and have an extra easel on the side that remains there for the whole trial, so that as these names are being thrown at the jury, they're not used to, they will know it by the closing. But we can always refer back, that's the HR person we were talking about. And, next up is coming the second level supervisor, and we could point to that on the board, and then they know exactly where this person falls in the organization. So that I'll use a combination of boards that are blown up. Maybe the top 3, 4, 5 documents in the case will go up on a big blow up, and that can be written on if needed. And I love using just a big pad of paper on cross-examination as the cross-examination is going on. I put the witness's name at the top, the day, Wednesday or whenever we're crossing, and writing down some of those key things that this witness is saying on cross-examination, so that in closing argument that can be returned to, and I can show the jury, really, you remember this person on the board here said these things on Wednesday. And visually, there's now a connection to that, as opposed to just everything being said. I do think it's as much as you can, have all the technology as smooth as you possibly can. I personally love an iPad and be able to control those documents myself wirelessly in the courtroom. It's not always possible. Sometimes they're not smart courtrooms, and you need to use some other tech on that. But in employment law, there's so many emails, there's so many documents, that if you are spending time trying to find the next one, or the jury can't see it. I was just in another webinar last week. We were talking about sight lines. It's great for storytelling to have these things, but be cognizant that the jury can see them and see them clearly, because you may be referring to it, you may be saying your story really well, but if they can't see what you're talking about, they're going to get distracted. Your story starts falling apart. They're not paying attention anymore, and you've lost them. So those are just some practice tips I'd pass along.
Laura, you mentioned when we were in person about the Starbucks cup. Do you remember that? You should say
Well,
that story. That was great.
I've used variations of this over the years, in visualizing the burden of proof. I think that's another very key thing that we have, is that the burden of proof being preponderance of the evidence. And I've often used just a glass of water, and I've put on the screen on a PowerPoint, an empty glass of water that has a line halfway through, and then almost all the way at the top. And I say, all right, all the way at the top, that's preponderance of the evidence. That's what you deal with in a criminal case. And that's how much you would need to fill this cup with evidence all the way to the top, basically. Not quite, but almost there, to prove that beyond a reasonable doubt. But here in a civil case, we have preponderance of the evidence. And so if you imagine all of the evidence poured into this glass, and you get all the way halfway, but then you have one more drop of evidence over that, we have met our burden. And in closing, sometimes in some trials, if it makes sense, I've physically had like these little animations where the pieces of evidence drop into the glass, and it not only passes the halfway point, but goes all the way, over. In Starbucks, I did a variation of that, where I had a Starbucks cup on one side of the screen, and an old mug on the other side, a cup of Joe. And so every time we talked about the evidence, I talked about the evidence in closing, I would put the evidence that was in our favor in the cup, our cup of Joe. And by the end of it, there was no evidence in the Starbucks cup. So that was a way to like visually get the jury to see who has, this is about the evidence, and who has it, and do they have enough? And we were able to show we had enough.
I think it's so interesting, because I'm never really in front of a jury. You have this interactive moment with them that you don't really have in writing. In writing, it's sometimes much harder to not use conclusory sentences and to really show the story through your writing. Brian, you teach. How do you teach your students to do that?
Basically, teach them to, again, the show don't tell, we talk about using, saying what somebody did and then trying to use, really good verbs and nouns, not too many adjectives, but really trying to give the detail, tell what somebody did. And if you're going to make the conclusory statement, make it after that, perhaps. But the goal is that the judge who's reading the brief will come and see that. So sometimes just the facts are more powerful for a judge who's used to being told things all the time and argued things to. I think it'd be very powerful if you just lay out the facts, but lay them out in a way that the judge reading it can picture what happened. Maybe talk about the characters a little bit more than you would talk about how somebody, if you have deposition testimony about how somebody acted, then put that in. Another thing that can work, and one thing Lori's so great at, is the visual stuff. And I don't know how much teaching you've done, but Lori, but you'd be fantastic because you're teaching the jury, clearly. And I think that's great. And thinking about the different ways we learn. Some people are more oral, others are more visual, others are tactile. That's kind of complicated in a jury trial. But in any event, you can do things in briefs and the like that a lot of people don't think of, like drop a chart or graph in there. Doesn't hurt. In a case I'm in recently, we did that at the beginning of an expert report. Just instead of saying, hey, boom, here's the chart from from relevant government agency in that case. So I think that thinking of visual things can be helpful. So I want to throw one thing out there. I can't say it was that successful, but I'm just going to tell you about it anyway, which is I was having problems a few years ago trying to get the other side, and you've probably all found this. You try to take 30B6 depths and you run into like every roadblock, obstacle you can think of. Scheduling issues, then the meet and confer arguments over the topics, etc. I had one a few years ago that was particularly annoying, and it just dragged on and on. And I wrote I think it was a letter to the court, and I mentioned the difficulties that were going on, but what I did is I just put in I put in into the letter, I cut and pasted the cartoon of Charlie Brown trying to kick the football and Lucy pulls it away or whatever, so it was Charlie Brown on his back. Now I can't say this like led to great success or anything, but I thought it was pretty effective in any event. But kind of thinking of that, you got to use your judgment, of course, but I think if we can be more visual, and this is something I'm working on myself, like how can I be more visual in my legal writing? I think it would be welcomed by most judges.
It's interesting you say that, not the Charlie Brown thing, which I think is hilarious. But recently I've been using more exhibits that I would have otherwise attached as exhibits into my complaints.
Right.
Like I have a wage and hour collective and class action that's a misclassification case, and the employer's main defense is that they don't actually pay the misclassified insurance agents. They're paid by a separate company. So in the complaint, instead of just saying, that this company is the one that makes a determination about commissions, we put in the chart with the company's logo that says, this is what you get on the first day you start, and this is how commissions are calculated. You could talk about that in the complaint, but I think seeing the logo and seeing it right on the page is really effective.
Yeah, I think that's really important, Miriam, because it's if somebody stands up in opening and says, well, this person's, my client was a salesperson and they sold, they met all their quota for the 6 months, and the comparator male, didn't make the quota. that's a conclusory statement. If you have the facts, then put the facts up.
Mhm.
Or you could put it up on the screen and say the quota was 90, she hit 90. The quota was 90 for him, he was at 68. That's much more persuasive than just saying the conclusion of the statement. And I think just being as specific as you can is what's gonna, okay, now I don't have to like think about that. Is that gonna be proven later? What's gonna happen? You can just say it or
Yep.
show it
It-
if you can.
Yeah, that's the old, I hate to say it, but picture is worth 1,000 words. I mean, it can do that. And I recently, in an arbitration, the it was Jam's arbitration. The other side wrote the letter saying they wanted to file a dispositive motion, and I thought I should probably respond to this because I thought it'd be a waste of time, which I said. But I put in an email, rather than tell about the email, I just put it right in to this, responsive 5-page letter. And I'm like, you know what? I highlighted the killer text in yellow, and there's no dispositive motion. We're just going straight to the hearing. So I think, yeah, if you've got some fantastic exhibit, don't think that the court's necessarily going to flip to it, especially when these days probably a lot of judges are reading the PDFs. And, if it's some really great thing and it's not going to take up too much space, put it right in there, put it right in there. Breaks up the monotony for the reader as well.
I want to make sure that we have some time, Ashley, for questions. I don't see any in the chat, but maybe I'm doing something wrong.
I don't see any yet, but anyone who has questions, now is a great time as we come up kind of on our last 10 minutes to go ahead and pop them in the chat or the Q&A.
If we don't have any, I can give my sort of I hate to say final, but a bit of advice.
Yeah, go for it.
Okay. One of the things I'll share this because I think it can be helpful. The question is, how do we do this? Again, it's not exactly it's not, do I have it, does it say watch documentaries on the screen that I'm
Yes.
sharing? Okay. We wonder how to do it because, again, we're not, unlike the novelist or screenwriter, we're not inventing this stuff. Like, we're trying to find out what happened and then present it in a way that is the story. So we're making order out of chaos as well, when we're trying to figure out what happened. And a lot of, when I and some other people were first, teaching this stuff, we would talk a lot about fiction writing, and then it kind of clicked on me, fortunately early enough on that, what we really are is documentarians. We're like documentary makers, in a way. People who are taking real events and telling the story and telling it in an interesting way. And no matter how objective somebody wants to be, they're always going to have some kind of angle, some kind of, dare I say, bias or agenda when they're doing it. And they're often telling a story that people know about to some degree. So they're confined by the actual facts, but the other tools become much more important. So one thing I recommend is to sort of get a sense of this, is to watch documentaries. Read history books if you want as well, but watching the documentary can be really helpful because you're seeing, how the documentarian did it. See what point of view they're using, who are the characters they focus on, what events did they focus on, what order did they put them in. So, for example, you could have, the example I like to use is the Titanic. A lot of people know that story. Watch a few different documentaries about it. Where does this one start? One might start with the building of the ship in Belfast. Another might start with the Titanic about to hit the iceberg. Another documentary might start with the submersible that found it in 1985. There are all these different ways to start. One documentary might focus on some of the passengers. Some documentary might focus on the captain, et cetera, et cetera. So so I think that you start getting the idea of the options available to you and what can be most effective. And then think about your own case. You have a bunch of different ways to tell the story. Which witnesses are you going to put on? What order will you put them on? Which documents will you use? Which order will you present them in? So think of yourself as a documentarian, a documentary maker, and this becomes maybe easier to conceptualize and probably a lot more fun too.
We have a couple of questions. One from Toby Marshall. Hi, Toby. It says, can Laura clarify what she was saying about having a piece of paper with key statements from a deponent? Is this made an exhibit in the deposition in a trial, perhaps illustrative, or is it something that she's creating using herself to prepare for hitting key points in closing?
It's a large easel pad that is put on the easel, and I use it during the cross-examination of the defendant's witnesses during the trial. So there's nothing written on it prior to the examination. I have in my head the key things that I hope that I'm going to establish with this person. And so if I do get them to say that, like you knew, that she was, getting sick. I'm keeping using a pregnancy case because I'm working on one. So, if she's getting sick in the bathroom, 3 weeks before the termination, you were aware of that, right? Yes. Okay. Aware of, sickness, something. I'm just putting key things under this witness's name on this large easel pad. And then it's just a demonstrative, it's not evidence itself. So during closing, most judges will let me bring that up. And as I'm going through what the different witnesses told us and the evidence that we established, I flip back to that and I say, you remember Joe, and he was up here and he said these things. So it's, especially if you're in a long trial, there's a lot of witnesses, you forget what happened 2 days ago. It helps you get back to what was important, and it was they'll remember that you wrote that live, so it happened. I don't know if that clarifies, if he has any follow-up there. Brian?
Quick point, like one thing that's so brilliant about what Laura does is the trial itself is a story, from a beginning to an end, and the jurors are, they're observers, but also participants, especially at the end. And, this idea of bringing them back to that notepad, it's like this shared experience that you're all having. They've seen you, oh yeah, I remember when we did that, I remember when she wrote that up there. And I think that's great. And the idea of the things that what Laura says to the jurors at the beginning, I think is important as well, because again, it's like we're also, you don't have to say this, but we're living a story right now. This trial, this event has its own story to it. And now I can point you back to something that happened in our story last Wednesday, for example. So I think it's really great.
Another question we have is, I'm a new associate and I often get feedback that my legal writing is repetitive when I repeat a fact during legal analysis, for example. When presenting cases to juries, is repetitiveness something to avoid or something to lean into? Is there a good balance to repetition when presenting at trial? I have some thoughts about the writing, but Laura, do you want to talk about the trial piece?
Yeah, sometimes they talk about the rule of three, say things 3 times and they'll remember it. My feeling with the jury is you want to be as tight as you possibly can. You want to be up and down. The direct of the plaintiff has to be as short as you can make it and get out. Same even with the cross examinations, tight, short, down, because that jury, you don't want to be the seen as the one that's wasting the jury's time, and they're smart. They're going to get it. So I try not to harp on things during cross-examination and keep banging the same drum. Make the point and then revisit it in closing. Make the point, revisit it in closing. And it's just, there's, I think sometimes mistakes attorneys make, they make the trials too long. Almost all of mine can get done from Monday to Friday. Just try to pick those witnesses that are going to get that story told, and not to go off on a tangent, but sometimes I'll call the defense witnesses of cross first and not the plaintiff, and tell the story through the defense witness. But to do that, you just got to be prepared and know what you want to establish through them. So I would say, the short answer is try to decrease the amount of repetition that you can, maybe repackages in a different way so that you're more arguing that fact as opposed to just restating it. But certainly in trial, you don't want to be repetitive to the extent you can help it.
I think in legal writing, what we've been taught in law school, at least what I was taught a long time ago was, IRAC. So you have this formula and you're set up with this formula. And then as a new associate, you're like, okay, I have to follow this formula. So you put in the issue and the rules and the application and the issue sometimes mirror each other. When you start doing that, there tends to be a lot of repetition. And I think a way to do that is either to make the facts section quite long and applying it within the facts. I've done that. But there's ways to formulate it so you're putting the application of the law closer to where the facts are. So you're not putting all the facts out at once and then repeating all the facts under the applications. And I think you just have to sort of play with it, read briefs that other people have written. When you're writing a complaint, a lot of times it's very easy to fall into these conclusory sentences. I've been working today on a forced labor complaint, and so I'm thinking a lot about coercion, right? And what is coercion, and thinking about how to prove coercion in these different ways, right? And all of these little facts go into what makes this environment coercive. And so I think thinking about how to tease those facts out in your writing, but not necessarily repeating them, is really important. And it sort of becomes a fun art
I was
to
going to
try to
say,
make it. Yeah, go ahead.
no, I was just thinking, sorry, I didn't want to interrupt you. If you're, it's just saying, like, go back to the word why. Keep think if you're saying the fact again, like, then why? Why is that fact important? And I think that'll make the fact differently stated. If it's just a fact, it's just, then why is that? Tie it back to either like it's important because it goes to this element, or important goes to this piece of the story that proves the element. And that will get you away from the conclusory nature of it.
The last question, I think we only have time for this last one. What's a good way to explain circumstantial evidence? I've used a few hypos, for example, dog ate the cookies, but no one saw, kid with the lipstick on the walls, wet umbrella inside, but didn't see it raining. And juries want a better one that I don't yet have.
I hate them. I hate the rain one. Judge Rice says a lot. Some of the judges use, and it's worse because the judges are going to read a circumstantial explanation to the jury, and they all stink, honestly, in my opinion. It's common sense. That's what I say. It's like, what happened here. This is what happened. Is somebody going to walk in here in 2024 and tell you, oh yeah, I fired him because he's old? No, it's never going to happen. But how do we know it? It's because if you put all these pieces of evidence together, and I don't differentiate between direct and circumstantial evidence. Like, I probably never have used the word circumstantial evidence in my closing or any in my argument. Now they're going to hear it from the judge that, it's a guy walks in with an umbrella. Do you think it's more likely it was raining and he's sopping wet? I mean, to me, that's like direct evidence. I don't know how clear it could be unless he's crazy. So, but I just hope by that point they understand that it's lack of admission, it's lack of somebody coming in and just fessing up to it. It's a whole bunch of things put together. Maybe sometimes I have said, like, you're not going to have one thing, but when you put all of these things together, they add up to this. Is maybe a way to do it, but I haven't found an analogy that I can use as a lawyer in closing that a judge isn't going to get mad about, because there's the form interrogatory, the form jury instructions have a definition of circumstantial evidence, and that's what they're going to want to, that's what the judge is going to go by, and they don't want you as the lawyer repeating the jury instructions in your closing argument. So I really don't directly address it in that way.
Well, thank you all so much for being here. We really, really appreciate it. Looking forward to trial boot camp next week for those of you who will be there. Laura, Miriam, Brian, thank you again for doing this. We'll be circulating a recording. The recording will be available for people who were unable to make it, and we'll be circulating Brian's PDF. So thank you again for joining us, and we'll see you at our next event.
Thanks, everyone.
Thanks, Ashley.
Good luck, everybody.
you.
Good
Thanks,
luck at
Ashley.
camp. Thanks.
Bye-bye.
All right. See you all. It's great to see you.